factual situation to effect.
Right.
If 4 years later the legislature says, starting next year, here's the law, well, your battle took place 5 years ago, and the law that was in effect at that time is the law that's going to control your case. For the large part. There's a lot of, there's some ifs on it and stuff like that. Sometimes the legislature will pass something and say, this is retroactive. And then the parties will litigate the hell out of that, you know. But still, we have the concept in our law of you don't get a second bite of the apple. You've had your trial, and you've had your appeal, and 3 years later they change the law. That doesn't mean you get to go back and sue the guy again under the new law. Okay, that makes sense? Okay. Anybody else? Okay, that's the structure of the courts in Florida. That's 3 levels. Forget 4 colors. 3 levels of courts. Just like the diagram in the book said, most state courts have 3 levels, so do we. So is the federal system. That was the state courts. The chart in the book on federal courts is excellent. And of course it's accurate because the federal system is what it is. It doesn't vary from state to state. What's important to note is, again, 3 levels of court. Now, we elected our judges in Florida. Does anybody know how you get to become a federal judge?
Wait, you said federal?
I'm sorry?
Federal judge?
Yeah, how do you get to be a federal judge?
Appointed?
I'm sorry?
Appointed?
Yep, how long is your term?
For life.
Life.
For life, that's what's important.
Yeah.
All federal judges are appointed by the president, and all federal judges, even your local federal judge who lives down the street, has to be confirmed by Congress. The ones you hear about are the confirmation hearings as the Supreme Court justices. But every local federal judge even has to be approved by Congress.
So he goes out there?
I'm sorry?
So
Sometimes they have hearings, sometimes they don't. You know, it's obviously it's a political job, and it's the confirmation hearings are political as hell. You know, he's a judge. He's not supposed to be a Democrat or Republican. Well, he is. And if he's been a judge before, he has rulings that they can say, you know, we don't like what he did on abortion or whatever. But most importantly, it's for life. So this is a real big deal. You don't throw him out after 6 years if he's doing stupid stuff. There's only one way to get rid of him.
kill him.
No,
Kill him?
They die. Question. How long do they have to be judges before they can be appointed? Like, is there a limit, or is there a prerequisite?
How long do you have to have been a judge before you can be appointed?
Right.
I could be appointed tomorrow. I've never been a judge.
Okay.
Being an
I've never been a
attorney?
judge before.
You have to be.
You have to be a lawyer.
Yeah, lawyer for sure.
You have to have a law degree.
Yes.
And you even have to be a practicing lawyer. You have to have a law degree.
Is that for any judge or just for federal?
I think
It's a random question.
I think it's any judge.
Okay.
I mean,
that
it
makes
certainly
sense.
it certainly is in the main court systems that we talked about in Florida and federal. You have to have a law degree. There are all kinds of lesser judge type positions called magistrates, justices of the peace, and funky little things like that. Often they don't. Y'all may or may not know, we used to have municipal courts, city courts. You know, these court systems we've talked about here. We're talking about the federal court system now. The other court system we talked about was the state court system. That's it. We talked about sources of law can come from feds, or Florida, or county, or city. Well, we don't have county judges. We have judges of the county court, but that's a state court. But we don't have county, we don't have court systems set up by Broward County. We don't have court systems set up by the city of Fort Lauderdale. We did have municipal courts in the old days. They were abolished in Florida in 1977. Used to be if you got a ticket from the city of Fort Lauderdale Police, you went to the city of Fort Lauderdale court. Pretty well imagine how well you're going to do there. And that's part of the reason they abolished them. They wanted state judges hearing criminal offenses charged by city police. So we have a state court system only, no more municipal courts. Yes, ma'am?
In New Jersey, they have the municipal courts.
In where?
New Jersey.
One more time.
In New Jersey?
Really? Okay, they still, they still do?
Yeah, they
Okay.
still do.
And they're, you know, their jurisdictions are limited, and they're usually limited to
Traffic mostly.
police traffic matters that took place in their city.
Or less than, up to $500 or something.
They could be. Interestingly, you all know where our Fort Lauderdale City Police Department is. On Guard Boulevard, real near the fork of the river there, just west of downtown. Yeah, well, the first building right out front was the courthouse. I mean, once again, if you missed my drift, if you get a ticket from the city of Fort Lauderdale Police and you're going to court in their building with the guy, you know, you're not going to do well. They abolished municipal courts. But I think we were focusing on what are your qualifications to be a judge. In the federal system, it's did you get appointed by the president? Did you get confirmed by Congress? And you're in, and we talked about how else can you get rid of one other than killing them. You all know? You impeach a federal judge, just like we talked about impeaching a president. It's a big deal. Impeachment is a trial in Congress. Congress acts as, I think the House is the jury, maybe, and the Senate is the prosecutor, something like that. Point is, you have a trial in Congress, and if you are impeached, then you're thrown out of office. We have had one federal judge impeached locally, and believe it or not, as soon as he was thrown out of office by Congress, or being impeached for doing bad stuff as a judge, he was turned right around and elected as a member of Congress. And he's sitting as a member of Congress right now. There's nothing to do with nothing except that that's how you get thrown out of office, but that doesn't mean you can't be a federal judge anymore, but you can, if the people like it, they can be brought back, obviously, to Congress. In any event, 3 levels of courts here. Now, the first one, called the United States District Court. That's your trial court. There are 3 of those courts in Florida. Not real complicated. There's one for the Southern District, there's one for the Middle District, and there's one for the Northern District. Notwithstanding that, for example, we are pretty obviously in the Southern District, and we have a federal courthouse downtown in Fort Lauderdale on Guard Boulevard. The Southern District of Florida also has a federal courthouse in Palm Beach. It also has a courthouse in Miami. And these federal judges, excuse me, the term is ride the circuit. Now that circuit's a bad word. Ride the district. They hear cases in all different places. They're all members of the Southern District of Florida. They were all appointed by the president, confirmed by Congress, serving for life. They're all federal judges. It's important to note that every district court has a bankruptcy court attached to it. You hear a lot about bankruptcy? Bankruptcy courts are all federal. They're not state courts. Bankruptcy law is all federal law. It's not state law. It's another one of these areas where the federal government is preempted. And each courthouse has bankruptcy judges who are U.S. district judges and have bankruptcy hearings, for example, in South Florida, in Miami, Fort Lauderdale, or West Palm Beach. There could be a bankruptcy case filed in the Southern District of Florida, which is our district, held in any one of those courthouses. Okay. Similar to Florida, we have an intermediate appellate court in the federal system.
Really quickly, you said there was a federal courthouse in Palm Beach, Miami-Dade, and Broward, but you
Yeah.
said there's only 3 district courts.
There are 3 districts in the whole state of Florida.
Okay, so there's 3 districts.
It's called, this is confusing, I understand. It's called the United States District Court for the Southern District of Florida. It happens to have 3 courthouses.
Okay.
That's it, much as I can say for it. There's a line
So when
somewhere.
it says 94 district courts,
Those are 3 of them.
3 of them.
Those are 3 of them in Florida. Yeah, 3 of them are in Florida. We good on that? Everybody okay? All right, we move on now to the Intermediate Appellate Court. It's called the United States Court of Appeal. There are 11 of those in the country. We're in what's called the 5th. It's in New Orleans. New Orleans is our United States Court of Appeal for the 5th Circuit. Now, we don't talk about that 5th Circuit much because that circuit gets real confusing with Florida because our circuit court was our trial court in Florida. You're going to find these names will really throw you. The trial court in New York, for example, is a Supreme Court. Just is. So I want to avoid the labels of, you know, circuit and supreme and superior and all these things. The name of this federal appellate court is the United States Court of Appeal. Same thing, judges are appointed for life, appointed, confirmed. These, similarly to Florida, these are panels of judges. I think it's 3, maybe 5, hear your case. Forgotten which. They issue an opinion. It has a holding. Their opinion is precedent. All the district courts in their turf, so to speak, in the 5th district, in the 5th Circuit, which is Florida, Alabama, Mississippi, obviously Louisiana, a couple others maybe, southern states. When this court rules, every district court in that circuit, meaning those states, has to follow. That's precedent. That's judge-made law, and the lower courts have to follow. Same things we said before apply also to these federal courts. The district court, the trial court, is the one that hears the evidence, has the witnesses, determines what the facts are, applies the law. The appellate courts, like this United States Court of Appeal, and of course the Supreme Court, no witnesses, no testimony, no jury. Simply, was the lower court correct or not in its application of the law? And obviously the U.S. Supreme Court. Probably the court you're most familiar with, because its rulings get the most publicity, obviously. The United States Supreme Court, of course, you know it has 9 justices that they're appointed for life, confirmed by Congress. I don't know of any rules as to how they have to rule, because we see 5-4 all the time. Party lines everybody talks about. Of course, they're supposed to be nonpartisan. You don't know whether they're Democrats or Republicans, but you sure as hell know what type of president appointed them, what was his party, and who was in control of Congress at that time when they got approved. So we've got some conservative Republicans, and we've got some more liberal Democrats, and we've got some swing votes. Apparently the ruling 2 days ago on upholding Obamacare, there was a surprising rearrangement of the conservative justices there to support Obama. And likewise, considered to be a somewhat liberal ruling yesterday on gay marriage, in the sense of the alignment of the justices 5-4 there. In both of those cases, scathing is the term often used, dissenting opinions issued by the judges. I disagree with the majority, and here's why. Interesting. Doesn't mean a damn thing. Not binding, not the law of the land. Only thing it tells you is this is what this guy thinks if we come back here again on a similar issue. That's the federal system. Anybody have any questions? Okay. We're going to shift gears completely here now. There is no good other spot for this topic, and it's a real important topic. And the topic is alternate, or sometimes people say alternative, dispute resolution, ADR. This is huge today. What we've talked about, of course, is where does law come from, and how are these areas of government set up, and most particularly how are the courts set up. What this is all about is, what if you have a dispute? And of course this means a civil dispute, not a criminal dispute. What if you have a civil dispute and you want to get it resolved without going to court? So this is dispute resolution, alternative or alternate dispute resolution without going to court. Kind of makes sense then. Alternate dispute resolution. Let's talk about for a minute, how do you get there? How do you end up in alternative dispute resolution without suing somebody? Yes? Go ahead.
Wouldn't it be agreed in a contract?
That's one of the three ways. Good for you. There are three ways you can end up in alternative dispute resolution. One is you sign a contract and agree in advance. Hey, if we get into a fight later, we're going to use alternative dispute resolution rather than going to court and suing each other. It may be partial, it may be complete. It may say you can try these things in, go to court, but the point is, contract is one way. You sign a contract and said, we'll do that. The second way is there may be a statute that says, if this type of matter happens, it shall be, like condominium cases say a lot. Condominium statutes, condominium regulations by the division say that these dispute matters between a unit owner and his condominium board should be handled by alternative dispute resolution. And thirdly is you can plain old agree. I can say to you, we got a problem, and we can go to court and sue each other, or I'm going to sue you, or you want to try to work this out through alternative dispute resolution, and you may agree, in which case we don't need anybody's help. We go down the path of alternative dispute resolution. And I'll tell you what the two ways to go down that path, which we'll talk about in a minute. There's one other way that you can end up in alternative dispute resolution, and that's a court order. The court, this means you had a lawsuit, and the judge ordered you to go try to resolve your case in the alternate method. I realize this is all kind of vague and confusing, and we'll talk about those two methods in a minute, but the point is, I sued you, and we got before the judge, and the judge says, rather than me deciding this, rather than witnesses' testimony, jury hearing, discovery, depositions, bleh, why don't you two go see if you can work this out through alternative dispute resolution? And of course the judges eat this up, gets it off his calendar, ain't his problem anymore. Judges have these clogged dockets and all this work to do, they all whine about being overworked all the time. They'd love to get rid of a case, get you two out of there, and you guys go resolve your problem somewhere else. So in many cases, in almost all cases now, before you get to trial, the judge will have already ordered you to go into alternate dispute resolution. And it failed. And now you're back and let's have the trial. All right. Two things, very simple. Mediation and arbitration. That's what this is. All this gobbledygook about ADR and everything, it just means two things. It means mediation or arbitration. And obviously I'm going to try to explain the differences to you. The first one is called mediation. Mediation is a neutral third party meets with both sides, tries to help them settle. Here's what's most important. The mediator, that's who has mediation, that's who conducts the mediation, the mediator, does not render a decision. He doesn't take sides. He doesn't make a ruling. He tries to urge the parties to settle. I'm going to walk through that with you in a minute, how he does it. So picture this. You've gone to the judge. You guys have a dispute. Judge says, go see a mediator. See if he can help you settle. That gets rid of the case. For a while, and we'll discuss this again at the end in a minute, after we've outlined the procedure, every mortgage foreclosure, you remember our foreclosure crisis after the 2007 recession, et cetera, and all the underwater properties and the backlog of mortgage foreclosures, for a while, every mortgage foreclosure had to go to mediation. Now, it was a disastrous failure because the banks don't settle. But had to try, had to go through the motions, the delays, etc. All right, tell you what happens. The mediator is usually a lawyer, but not always. Mediator is licensed by the state of Florida to be a mediator. You got to take a bunch of courses. Then you got to go through a bunch of practice mediations to become a state certified mediator. I was one for a while. Didn't like it, quit doing it. But the point is, that means you're licensed to handle mediations. So what happens is, by the way, the courts can order you to attend mediation, but they can't order you to settle. The court says you've got to go to mediation, so you got to go. You're in contempt of court if you don't go. But nobody's going to force a settlement. So here's the procedure. You set up a meeting with the mediator where both of the parties and both of their lawyers will be there. They usually are lawyers already because you're in a dispute. Maybe you're already in court, maybe you're not, but you probably got a lawyer already anyway. And the mediator sits in a room with both of the parties, both of their lawyers, and they both tell their story. The aggrieved guy says, I was just sitting at a traffic light. This guy ran into the back of me. And his lawyer says, yep, that's what happened, and clearly he's liable, he ran into the back. Tells his whole story. Here's my damages, here's what I did to my car, here's how I messed up my neck, it ruined my life. Rule for me. Or not rule for me, rule, but me, I win. So he turns to the other guy, and the other guy says, nah. He says, I was sitting there at the light, listening to the radio. I looked up and this guy is backing into me, and I honked my horn 3 times and he backed into me anyway. He backed into me. Here's my damages. Here's what's wrong with my car. Here's my injuries. And his lawyer says, clearly, he's going to win. And they both say all the reasons why their case is great. says, okay, and that in and of itself, venting, helps a little bit. They both got to tell the other side how pissed they are and why. The mediator then separates them into separate rooms. Puts the plaintiff and his lawyer in this room, and puts the defendant and his lawyer in the other room. And basically the mediator goes back and forth from room to room and tries to get them to settle. He sits with the first guy and they say they'll take $20,000. Tell him we'll take $20,000. He goes over to the other room. He says they'll take $20,000. This is a great idea. It'll save you the cost of trial. It'll save you the years and heartburn and expense. Why don't you pay him $20,000? And the other guy will say, nah, tell him the pound sand. They're making up the whole thing. Tell him we'll give him $1,000. And he goes back and forth, and they each say what's wrong with each other's case and why we're going to win. And ultimately, maybe they agree. Maybe they end up at $10,000 in the middle. And if they do, the mediator writes up the settlement, they both sign it, the court can enforce it, matter's over. Mediation was successful. Maybe not. If not, if it was a court order, well, you're just back in court and you finish your litigation. Now, what I didn't say at the onset, and I should have, is that the pitch in all this is, it's supposed to be faster, it's supposed to be cheaper, it's supposed to be less emotionally draining, and it's simpler. You don't have all this testimony of witnesses. You don't have depositions and interrogatories and all that bunk. You just sit down and see if you can work it out. That's mediation. That's alternate dispute resolution by mediation, which is a mediator tries to help the parties settle but does not make a decision. Okay. Arbitration is the other thing. Arbitration is more like a trial, but not by a judge. In arbitration, a neutral party is appointed again. Usually, that neutral party is an expert in the area of law that you're fighting about. Often construction. A lot of these disputes are contract disputes between contractor and owner, between city and road building contractor or bridge building contractor. So you bring in an expert. Often 3 experts. Sometimes you'll have a panel of 3. There are rules dictated by the American Arbitration Association of how arbitrations are going to be held.
American what?
Arbitration Association. AA.
Mm-hmm.
And this is a trial. This is witnesses, testimony, evidence, and the arbitrator or the panel of arbitrators are going to make a decision. And it's enforceable in court. And this is called binding arbitration. The parties are bound by the result. There is such a thing as non-binding arbitration, but it's pretty rare. Because why would you go through all that? There's a lot of expense here. The 3 guys you're appointing are probably lawyers charging $400 or $500 an hour each. Still quicker though than waiting through 3 years in the courthouse. But their expenses in these cases, they're usually split. Arbitration and mediation both, they're usually split by the parties. Usually. Sometimes in arbitration, the parties have agreed in advance. The winner won't have to pay the arbitrators and the loser will. But arbitration is a final result of your case, and once the arbitrator has ruled, if the losing party does not comply, The winning party can take that arbitration award into court and have the court enforce it. Can have the court levy assets, attach assets, do whatever needs to be done to make the loser pay. Questions? Yes, sir?
There's no appeal for the arbitration.
Neither one. Neither one. It's fine. You have, conceptually, you agreed to that when you signed the contract. Now, note if I could. Judges will not order you to go to arbitration. But if by contract or by statute you're bound by it, then you've agreed to it. You've agreed to the concept that the arbitrator's decision is final, binding, non-appealable. And that's why courts will only order you to mediation to try to settle. If not, come back here and I'll settle yours. Did you have a question earlier? I'm sorry.
No.
Didn't? Okay, thanks. Now, I want to take a look at something particularly and show you how this stuff comes into play. I'd like you to look at the two-page form that I sent you. Does everybody have that? Pieces of a contract, 2 pages out of a contract. Everybody got something to look at? No? Was that a no? Yes? All right. Let me tell you what this is. First page. I'm sure you know this, but when you buy and sell real estate, you sign a contract. Buyer and seller sign a contract. This is page 1, first page of a contract form. Florida Association of Realtors puts out this form. It's called the FAR contract, FAR, Florida Association of Realtors. If you're a realtor, you know that. This form was supplied to me by a friend that's a realtor. That's what this Town Real Estate is. That's the name of this firm. Only realtors have access to this form, but everybody uses it. When buyer and seller agree that they're going to buy and sell a piece of property, they sign up one of these things. You see down the lower right, this is page 1 of 9. Even for the simple sale of a house, the sales contract is 9 pages long of all the stuff you're agreeing to that you might fight over. This form starts out, as you see right at the beginning. Line 1 is the seller, line 2 is the buyer, and they agree to buy and sell all property on line 4. And you describe it with a legal description and all that kind of crud. And then you go on into the purchase price and terms, etc. That's what's going on in this contract. Now, we're going to talk about that on the second page I gave you in a minute, but I wanted you to have the drift of what we're dealing with here. We're dealing with a sales contract between a buyer and a seller regarding the sale of a house. This is a residential form contract. Go over to the next page that I sent you, which is page 7 of the same form. We're still going. Buyer and seller are still agreeing to stuff here. Paragraph 16, line 345, in the middle of page 7, is called dispute resolution. Everything here except the word alternate dispute resolution. This says, beginning at the end of the first line, all controversies, claims, and other matters in question arising out of this transaction or this contract or its breach will be settled as follows. This is one of the ways we talked about to get into alternate dispute resolution by contract. The parties signed a contract and they agreed right here. We're not going to sue each other. Here's what we're going to do. Now, before we go there, think about it for a minute. This is a realtor's form. Realtors want it resolved quickly, inexpensively, and of course they want the deal closed. But the point is, they don't want to wait 3 or 4 years in court if the parties are having a dispute. So in the realtor's form, the realtors have decided you're going to have alternate dispute resolution. You don't realize it when you look at page 1 and you see what the purchase price is, and that's all you care about. But over on page 7, you agreed to this. Okay. Now, it says it'll be handled as follows, and then we're going to talk about A and B, the different kinds of disputes. But if you look down in C, it's going to explain to you the stuff that we just talked about, and I want to go through that again for a minute. C, mediation and arbitration. Mediation is a process in which the parties attempt to resolve a dispute by submitting it to an impartial mediator who facilitates the resolution of the dispute, but who is not empowered to impose a settlement upon the parties. That's mediation we talked about. You go down to the middle of the paragraph, in the middle of line 370, arbitration is a process in which the parties resolve a dispute by a hearing before a neutral person who decides the matter and whose decision is binding on the parties. That's, of course, binding arbitration. Arbitration will be in accordance with the rules of the AAA. We talked about that. That's defined above. And it goes on now to say who's going to pay the cost of arbitration or mediation, and usually they're split by the parties. So they've told us here what the procedures are, and now they tell you we have two kinds of disputes here. Dispute in A is a fight over the deposit. That happens all the time. Buyer puts up a deposit, parties decide not to close for some reason, they fight over who gets the buyer's deposit. So, type A is a dispute concerning the entitlement to deposits. Parties have 30 days to have this matter resolved through mediation. If it fails, whoever's holding the deposit decides what happens next. Some third party holds that deposit. Often it's a realtor. So then the escrow agent, that's the guy who's holding the deposit, gets to decide whether it's going to go to arbitration or go to court, or God forbid, the worst of all cases, go to FREC. FREC is the Florida Real Estate Commission. It regulates realtors, and they issue rulings, often without any regard to what the contract says or the law is. They just decide, we as realtors think this is what should happen. In any event, if it didn't work it out, who gets the deposit in mediation? Then you're going to go one of these other routes, and that's what's going to happen to the deposit, and you've agreed to it. They'll say give it back to the buyer, they say seller keeps it, they'll say split it, they'll say give it to the realtors, whatever. That'll end your dispute. You probably won't go to court because the escrow agent is not going to decide that you'll go to court, because that just takes too long. Parties want to get this over with. Buyer wants to have the deposit back and move on and buy another house. Seller wants to get out of this contract. If we're not going to have a closing, for God's sake, let's get this thing over with and let me move on and sell it to somebody else. So the idea is speed, less expense, simplicity. Now, all other disputes. There are lots of other disputes that could come up that are not just fighting over the deposit. Says once again, we'll try to settle them through mediation. Failing which, the parties will resolve the dispute through neutral binding arbitration. Goes on to say the arbitrator may not alter the contract terms or award any remedy not provided for in this contract. The award will be based on the greater weight of the evidence, which means, not like in a criminal trial beyond a reasonable doubt, but he's going to listen to evidence, going to have a hearing, and findings of fact and contractual authority, and we may or may not have discovery. These are the rules. So, the point is, these are methods of alternate dispute resolution to resolve a dispute between parties, in this case between buyer and seller on a residential house sales contract, short of going to court. Supposedly cheaper, faster, simpler, less emotionally wrenching, and done. So, that's alternate dispute resolution. let's go back for a minute and review a thing or two, and at 12:30 we'll quit for lunch. We talked about the different sources of law. The 4 sources of law: Constitution, statutes, precedent made by judges, and administrative regs. They're not all nicely indexed in one place. You got to search around a lot to find the answer to your question. There are lots of courts cranking out decisions. State and federal appellate courts setting precedent. Intermediate appellate courts and supreme level of both courts. To get an answer to your question, or an answer to your legal problem, you may have to do a lot of legal research, where you research statutes and what the courts have said the statutes mean. A lot of legal research today is done on the internet. Simply through Google will get you a good ways. There are other legal research engines. I want to read you one quote that I think is relevant out of our book, that I think explains, dilemma's a wrong word, but the overwhelming amount of material that you got to go through before you can get a nice firm result. This is found on page 5, and this is not something you're responsible for, it's just something I want you to think about. Top of page 5, it says, one prevailing myth about the law is that all laws are found in nicely indexed, officially published volumes of statutes enacted by a legislative body. According to this belief, all you got to do is look up a statute, go to the correct page in the right book, and the law will be right there. Few legal questions are answered this simply. Thousands of cases, statutes, and administrative regulations are published each year. As a result, determining what the law is has become increasingly difficult. Computers enhance the potential for legal professionals and the public to access sources of law more effectively. The speed and manipulative power of computers has allowed increased control over the burgeoning quantities of legal information. To answer a legal question involving real estate, a person might have to examine one source or a number of different sources. Sometimes the answer will be found in the state constitution or the federal constitution. Most often, however, the answers to real estate questions are found in court opinions, often referred to as precedents, and statutes, and the regulations of administrative agencies. The different sources of the law are what we just discussed. So that's it. That's all I've got for you on Chapter 1, where our law comes from, and the corollary things about how courts are set up and what alternative dispute resolution is. Does anybody have any questions? Well, then let's break for lunch early. Did we say a half hour? Was that the consensus?
Yep.
All righty.
Or less.
A couple minutes after a quarter of 1. About a quarter of 1, a couple minutes later, we'll get back together and we'll finish her up. The other 2 judges. And if you've had a chance to fill out that little thing about where to go to school and stuff, give it back to me if you would. If you haven't, do it during lunch hour and hand it back to me. Thank you.